Yeah, so dear participants, dear distinguished speakers, I would like to start our today talk, Rule of Law and Corporate Actors talk. This is our first meeting, and today we will speak about corporate actors and the sanctions regime, and what is the rule of law saying about different sanctions regime. And it's a great pleasure for us, and actually it's a huge honor for us to have our speakers with us today. And first of all, I would like to introduce Michael Strauss, a professor of international law and international relations at the Center de Etudes at Center for Diplomatic and Strategic Studies. Sorry for my French language. I don't speak French, unfortunately, in Paris, and also a consultant to the UN in Geneva, dealing with unilateral sanctions and human rights. Also, we have today, and it's a great pleasure to have with us today Dr. Irina Bogdanova, who is an international law scholar. Currently, she holds a position as a postdoctoral researcher and has been based in the World Trade Institute, University of Bern. Over the past years, Dr. Bogdanova has published contributions analyzing various aspects of economic statecraft, mostly focusing on economic sanctions, the effectiveness and legality under international law, and her recent book explores the legality of unilateral economic sanctions under international law. Professor Iurii Barabash will join us today a little bit later. He has a very important meeting in Constitutional Court of Ukraine, but I would like to introduce him from the very beginning. He is a Vice-Rector for Research and Academic Affairs and Strategic Development in Yaroslav Mudryi National Law University, Kharkiv, Ukraine, and he is also professor at the Constitutional Law. He is chair of the Scientific Council of the Constitutional Court of Ukraine. And Ekaterina Deikala will moderate today's discussion. She is one of the prominent business and human rights name, and she is expert in international law, and she is the expert of Belarusian Helsinki Committee, and also my friend. Ekaterina, the floor is yours.
Thank you, Alina. Very glad to see all of you, and thank you very much for having me and to for opportunity to moderate this session. Very interesting and controversial and multidisciplinary and in general. So we draft a list of questions and prepare the list of questions which we would like to discuss today. At least just counter how the directions of our discussions. So, and actually, we can split these questions generally on questions concerning what concrete type of sanctions I apply to corporate actors, about some legal nature to some extent of these sanctions, about criteria, and about also effectiveness. Can sanctions against corporate actors be considered in principle as an effective tool for this purpose in the business and human rights context? So, and we start then from the beginning, and let's start with the question, what sanctions mechanisms in principle I apply to corporate actors, and what Ukraine specification, what sanctions regime is applied in Ukraine. But probably with first question, what sanctions mechanisms I applied to the corporate actors in principle. maybe is you can feel free and raise your hands, and I will give you a floor. I mean, all our speakers, but maybe probably I can address firstly this question to Irina.
Thank you all for being with us today. Thank you for the speakers, organizers, and people willing to listen us during their lunch break. So thank you for this question. And I, as a legal scholar, will start immediately from the discussion of the economic sanctions from a legal perspective and how they apply to corporate actors. So in fact, when we talk about economic sanctions, we should keep in mind that as of now, the very term of economic sanctions is a not legal term of art. So in fact, we end up in a situation where this term can be used to denote, to describe a broad range of diverse restrictions. And in particular, for the purposes of our discussion, I think it will be very useful to classify these types of measures depending on the actors who employ them, because this will have a bearing on the legality of these measures and their application to corporate actors. So from international perspective, from international legal perspective, to be more specific, there are several categories of economic sanctions: collective, regional, unilateral, and since recently we start talking about so-called private sanctions. I will try now to define each category and describe how they can apply to corporate actors. So when we are talking about collective sanctions, we're talking about sanctions which are authorized by the United Nations Security Council, according to Chapter 7 of the Charter of the United Nations. And these sanctions are presumed to be legal under international law. Although, and here the emphasis goes here, that I would like to emphasize that UN sanctions were also criticized for their negative impact on human rights of the populations in the targeted countries. In particular, it happened after several times comprehensive sanctions were imposed, and there was a lot of evidence showing negative impact on the populations in those targeted regions. And it was in particular this criticism that predated and even to an extent instigated the shift from so-called comprehensive to more targeted sanctions, or smart sanctions as they're sometimes called. So next group of sanctions is so-called regional sanctions. And when we talk about regional sanctions, we are talking about sanctions which are imposed by regional organizations according to their constituent instruments. And there are a number of organizations, of regional organizations, that allow these sanctions to be imposed on their members. For example, African Union, the League of Arab States, Economic Community of West African States, Organization of American States. So all these regional organizations, they have in their documents possibility of imposing unilateral measures or sanctions, such as, for example, of political nature, such as suspension of membership, or of economic nature, for example, embargoes, in response to certain violations of the rules or principles of these organizations. As well, when it comes to the legality of these measures, there is more or less a presumption, and well-accepted presumption, that these measures are legal, because members of this organization, they agreed that these sanctions might be imposed against them if certain situations occur. The next group of sanctions, which is the most controversial, is so-called unilateral economic sanctions. There are different terms which are used to describe this group of sanctions. Sometimes they're called non-UN sanctions. Sometimes they're called also autonomous sanctions. So basically, when we talk about these unilateral sanctions, we talk about restrictive economic measures which are imposed by a state or a group of states. In this case, we are talking, for example, about European Union, against a foreign state, its public bodies or government officials, legal entities, and individuals. And these sanctions are usually based on the adopting state's domestic laws. So they're taken only based on the domestic laws of a state that decided to impose these measures, despite the fact that they have implications for the international relations and international law. And the legality of such measures is still very contested in international law. And there is no one universal well-accepted acknowledgement that states are free to enact such measures. And what adds to the complexity of this issue is that this overarching question of economic sanctions legality also leads to a situation when in public international law, different concepts are used to describe such measures. For example, they might fall under the definition of retortions, reprisals, countermeasures, third-party countermeasures in collective interest, unilateral coercive measures. And I should mention here that the term unilateral coercive measures is used mostly in UN official documents. So here's the three main types of sanctions when we look at the sanctions from a perspective of who imposes sanctions and whether they are legal or not. In the context of the current Russian aggression against Ukraine, the new type of sanctions also emerged, and now it's kind of labeled as a private sanctions. And this term, private sanctions, it has evolved, as I already mentioned, in the context of the aggression waged by the Russian Federation against Ukraine in order to describe those sanctions which are imposed by private companies individually. So without decision of their government or without UN authorized sanctions. So it's in fact individual decisions of private companies, for example, to leave Russian market or not to invest further in the Russian market, even irrespective of the fact whether these measures are prohibited by the existing sanctions. So this is what is in the media has been labeled as exodus of private companies from the Russian market, what we have observed in the last year and a half. So all these types of sanctions are in fact applicable to corporate actors, but they apply in a different way. For example, when we are talking about UN sanctions are binding for all UN members. It means that these UN members have to implement these measures. And quite often, sanctions, by their very nature, they implemented by private corporate actors. So from one side, they might target corporate actors, and from other side, they implemented by corporate actors. So, and in this case, corporate actors, they are in fact the backbone of sanctions enforcement, and they play a significant role in enforcement of the imposed sanctions, irrespective of whether it's unilateral, regional, or collective sanctions. And private sanctions, it's already like sanctions which are decided by these private actors. So this being said, I would like to briefly talk about just a few words about what sanctions regime apply in Ukraine. So in response to this question, I can provide the following comments. When it comes to Ukraine as a member of the United Nations, and thus collective sanctions are obligatory are binding for Ukraine. Also, Ukraine often aligns with the sanction enacted by the European Union. In the European Union terminology, they are called restrictive measures, European Union restrictive measures. So it should be noted that while European Union invites other countries to align with its sanctions once the sanctions are imposed, such alignment remains optional for the countries outside of the European Union. So it's optional for Ukraine to align or not align with the European Union sanctions. But as a rule, what we can see in practice is that quite often Ukraine aligns itself with the EU sanctions. In other words, it implements domestically EU sanctions, although it's not obliged to do so. Besides this, Ukraine has its own domestic legislation that allows it to impose so-called unilateral economic sanctions. And in this respect, I would like also to mention that since the Russian invasion, Ukraine also introduced a new law and amended its sanctions legislation, and in this way established two parallel legal regimes, which also allow confiscation of the Russian property and property of sanctioned Russian national as a continuation of the sanctions, which is very interesting development, which also raises a lot of different questions in this context. I think with this, I will conclude my preliminary intervention, but I'm happy to answer any comments or questions from your side.
Irina, thank you very much for such a deep overview and introduction, a good starting point for our discussion. Maybe Michael or Lena want to add something on these questions.
Yes, I can I can chime in by saying that Irina's summary of this was pretty much aligned with my thinking as well, because it, in many ways, comes down to people's thinking because of the lack of precise definitions that pervade the whole sanctions environment and the questions of legality. There's no precise definition of unilateral coercive measures, which are generally equated with sanctions, but there's room to argue that perhaps certain ones are not, certain ones are. And the lack of precise legal terminology for what is a sanction, as Irina was discussing. The idea of private sanctions, though, applied by companies is very intriguing because it, when it comes to the rule of law, it has the potential to conflict with certain other business obligations conceptually, and that's where it can get really interesting. First of all, somebody starts a company, grows the company, and in general, they have the right to determine what markets to serve and what markets not to serve, as a matter of where they think their business will be good and where it won't be good. And it becomes very difficult, unless you're in a meeting of the board of directors, it becomes very difficult from the outside sometimes to determine why a company, why a corporation decides to be in a certain market and not be in a certain market. This also touches on the issue of over-compliance with sanctions that are state sanctions, or that are existing on the part of individual states, unilateral sanctions. For example, can be very confusing depending on how they're written and how they're enforced. And there are a number of companies that will simply not want to take the risk of either legal violation by accident, or they may want to reduce their reputational risk by not doing business with a certain country. That's a business decision, but it's also, it may, the origin of the decision may be different, but it ultimately has the same effect of a business not doing business with a certain country or with companies in a certain country. There's also the legal obligation that exists in a number of countries whereby businesses, this gets into securities law, but where businesses are obliged by domestic securities law to act in the best interests of their shareholders. That's, that gets into shareholder protection and things like that. So it becomes very difficult sometimes, unless a company actually announces its intention, to determine why a company may be engaged in what could be called private sanctions, but might also be called overcompliance, or might also simply be called complying with domestic securities laws. The whole thing is rather messy, as we can see, but that's what makes it interesting for people who look at it from a legal perspective. And part of the reason for this, I think, is because it's still a relatively new phenomenon and it's growing like crazy. And as a result of that, there isn't a long history of studies like there is, for example, with UN Security Council authorized sanctions. Those have been studied quite a lot by now, but these new things are still in a state of flux in terms of their development and in terms of the knowledge about them. It's one of the reasons why I appreciate the fact that webinars like this are put together, because, you know, little by little we can begin to get a handle on some of these questions. And one thing I also want to do in this context is express my thanks for having been invited to participate.
Thank you, Michael. I think that it's your intervention is a good point to move to our next question. And actually, that Irina said that the last development of Ukrainian legislation about private sanctions also is considered by can be considered as controversial one in the context of rule of law, I think. And actually, my question is what measures should be applied to ensure the compliance of sanctions with rule of law and human rights obligations? And should applying sanctions to corporate actors be based on regular rule of law requirements? Or we can say that it's okay to invent some emergency regimes for rule of law. So please, maybe Irina will start, or Michael, so as you want.
Yeah, well, I can start, and again, here I will probably start from international law perspective then, and I will add then, because I think for discussing this issue, we should talk about international rule of law and domestic rule of law. So for this question, I will distinguish between these two issues. And for example, from international law perspective, if applying sanctions to corporate actors happens when a company is being targeted and it entails some negative repercussions for this company, its business operation, its supply chains, its ability to operate on the market. So, and when, for example, this happens outside of the United Nations framework, in other words, based on the decision of individual states to target legal entities in foreign states, in foreign jurisdictions, these measures can be defined as unilateral sanctions, which is kind of, they are already quite controversial in international law, as we have mentioned before. And I think in this respect, it will be good to provide an example of such measures. For example, one of the examples is restrictions imposed by the United States against China's technological company Huawei, which prevented company from supplying some crucial components. And for example, in this case, export of some components and technology to Huawei, as well as its foreign subsidiaries, was prohibited. And what is interesting in this particular example is that also the sanctions introduced so-called foreign direct product rule, which applied to this type of sanctions. And according to this rule, even foreign produced item located outside of the United States was subject to these export restrictions if this item was a direct product of the US technology or software. So in fact, what we have seen with this example is that a sovereign state targeted a private company and its subsidiaries in another state and framed its sanctions in such way that even companies operating in outside of its jurisdiction, foreign companies, will have to comply with some of these measures. So it created very kind of effective type of restriction, but at the same time, it has a very significant impact on the business operations of Huawei, for example. And we have seen that they have to abandon part of their business as a result of these restrictions. So from international perspective here, in this domain of unilateral sanctions, we can see that in some cases, they might be very disruptive for private entities abroad. And if for this example, if, for example, we try to apply some sort of international rule of law to this example, then we have a number of issues that we have to resolve. And one of the first issues is, how do we define international rule of law? Because in fact, there is no one broadly accepted definition of what international rule of law means. And even if we take as a starting point of our discussion one of the most well-supported presumptions that international rule of law, it's in fact means that law or international law should define states' behavior at the international level. So even if we apply such a definition of international rule of law, then we end up with the question of what is the content of this law that should regulate states' behavior on international level. And with respect to our previous example, the question is, what law defines if United States had the right to introduce such type of measures to a private company, and what are the constraints on this right? So in fact, this whole discussion of whether such measures are allowed according to the principle, concept, or idea of international rule of law, it leads us back to the issue of whether unilateral sanctions are legal or illegal. Or another more even general question, which is legality of economic coercion and distinction between economic coercion, economic pressure, interference, intervention. All these issues, they have been discussed in the literature, in academic literature, for quite some long time. And since recently, we have seen a revival of this debate because of developments globally. So we have seen that since very recently, the debate on the permissible scope of economic coercion has been revived. And to an extent, this development was instigated by the practice of states that start to weaponize economic interdependence more often than before. So when we talk about legality of all these types of economic coercion, how do they relate to such issues as prohibition of intervention in domestic affairs of another state, or how can we distinguish between economic coercion and economic pressure? That we're all in this very complex theoretical discussion, and sometimes it's very hard to find a commonly accepted position on this issue. And that's why we always, like with these examples, we have abundance of state practice, which might raise different legal issues, but then we do not have even basic agreement on international level. Where do we draw this line between permissible and impermissible economic coercion? This makes it very complicated to debate these issues. And then this discussion is mainly about international rule of law. But then there is another chunk, which I would call probably domestic rule of law. So if you look at each particular jurisdiction that applies sanctions and its kind of legal frameworks, here it becomes a little bit easier because all the countries that frequently use this type of instruments, so all the countries that frequently impose sanctions, they all have their domestic sanctions frameworks. So all the domestic sanctions are enacted based on these legal frameworks. And as a rule, what we can see is that these legal frameworks, they prescribe some exceptions. Sometimes common type of exception these days is so-called humanitarian exception, when despite imposing sanctions, these legal regimes still allow for some type of exemptions on humanitarian grounds. Also, quite often these regimes allow licenses to be issued. And if the license is issued, it means that even conduct which violates sanctions would be allowed. So certain transactions would be allowed if there is a license allowing them. Additionally to this legal mechanism have established some sort of rules to challenge sanction. Again, we might debate whether these rules are effective, whether they give enough guarantees to different human rights, right to property, right to reputation, right to conduct business, and due process guarantees, and all these issues. So it's kind of still debatable to what extent each of these legal mechanisms, they provide enough of these procedural and substantial guarantees, but still they're more existent. So when we are looking in domestic rule of law issues, and when we look at the countries that explicitly impose sanctions and they have already some sort of established practice and established legal regimes, usually it's easier to try to frame them in the framework of rule of law, or argue that certain types of additional exceptions should be allowed, or, for example, that certain types of measures should be prohibited as violating the human rights or rule of law, general principle of rule of law. So that's why in domestic context it's easier. In international context, when we're looking at unilateral sanctions, even those types of sanctions which explicitly target private companies, we're still in this debate of whether they are legal and what is the status of economic coercion and the scope of legal kind of economic coercion under international law.
Thank you, Irina, very much. Michael, maybe you would like to add something?
Yes, in fact, that was a very good, once again, a very good summary of the problems. And they do touch on the big question of extraterritoriality in applying one's domestic law, because sanctions are becoming, unilateral sanctions are becoming a big area where this is being attempted, primarily by the United States, but there are signs that other unilateral sanctioners are looking at this and in some ways trying to emulate it. The enforcement aspect of sanctions is another way that sanctions are being drawn into questions of law, because one of the ways that the United States in particular is enforcing sanctions, including extraterritorially, is to impose sanctions on entities, companies, individuals that are presumed to violate its sanctions. So you begin to get this ladder effect, and you don't know where it's going to stop. You have second generation sanctions like this, often referred to as secondary sanctions, sanctions against presumed violators of sanctions. And again, you have the whole question of due process, which is a human right after all. But when it applies to companies, there you get into some questions of domestic law as well. But the due process rights are in the ICCPR. And yet sanctions in a very general sense at a unilateral level are often a substitute for due process. At least this is how they've developed in the United States and in other countries that are beginning to emulate some of the tactics and the ways that sanctions are imposed. Sanctions have tended to be an expedient way to punish a presumed, but not necessarily a convicted, wrongdoing party. It may be, it may be that the party is indeed in the wrong, but it hasn't been judicially determined to be in the wrong. And if there were due process, then there would be penalties applied on the basis of existing laws, and you wouldn't need the sanctions. On the other hand, if the party that is sanctioned is found to be not guilty, then the sanctioning of that party could end up being a wrongful act. So you end up with all of these different mixed in questions, which is what makes the imperative to research these things so essential, because we don't know all of the answers yet. Imposing sanctions against companies that violate sanctions for doing business with companies that are against that are targeted by sanctions at a national level. That's as far as it's gone so far. We have not yet seen what happens if there's a next level. For example, if you have sanctions against a company that's accused of violating sanctions, well, can you do business with that company without violating sanctions yourself? I mean, can it chain out ad infinitum? In a practical sense, no. But we don't, again, it's part of the newness of this phenomenon of sanctioning at the unilateral level. There's a lot that hasn't been explored yet. And as we'll probably talk about later, a lot of it pertains to human rights related issues and creates human rights related issues. I think I'll stop there.
Okay, thank you, Michael. Yes. Alena, maybe you would like to add something on this question?
I think we haven't touched on this idea of a new concept of rule of law for global emergency. I think as an idea, it sounds attractive because we might kind of use it as an instrument, for example, to say that if there is a global emergency, then states should have a duty to cooperate, for example, and if this cooperation doesn't work, then the states can go unilaterally and use. So in a way, this idea might be in a way used to kind of delineate legal, illegal, unilateral sanctions. But then again, a little bit of a problem that is hidden here is that, for example, first, it's as always like definition of global emergency. Who will decide if it's a global emergency? For example, when we look at the imposition of sanctions at the UN level, what we have seen in the practice of the United Nations Security Council is that the Council has a right to introduce so-called collective sanctions if there is a threat to international peace and security, if there is a violation of international peace and security. But then the issues which became the most heatedly debated, it was situations when, for example, there is a human rights crisis inside some countries, or there is a violation, there is a significant violation, grave violation of human rights inside of the country. And then at the UN level, we have seen already that there was a number of states who said that this situation should be addressed by also collective sanctions, that these states should be sanctioned for mistreating, for example, their nationals or their oppositional leaders, because in some cases, if there is significant aggression against broad civilian groups, it might lead to significant refugee crisis and so on. But then at the same time, we have seen a strong opposition towards this view. We have seen countries that have said that human rights issues, even if they have some sort of cause extreme externalities, they still matters of domestic concern, and they are should not be given any grounds for imposing collective sanctions. So again, when we look at this kind of global emergency idea of a rule of law for global emergency, meaning that if there is some sort of global emergency, then if some preconditions are met, sanctions can be imposed, but only defined types of sanctions with some sort of clear procedure under what conditions they might be lifted or what humanitarian exceptions apply. Then again, we're still kind of in this kind of situation where there are different views on what can give rise to such type of some measures and what cannot. So again, I don't see the just introduction of a new idea might resolve this confrontation that we have right now between the states in deciding in what circumstances sanctions can be used, even when it comes to collective sanctions.
I would agree with all of that, in fact, and also I would go a little bit further in exploring the difficulty of defining what is a global emergency, because you have sanctions that have been imposed by the United States, for example. I would think most of the sanctions regimes that the United States has are based on domestic laws in which there is a declaration of a national emergency, and that triggers a process that ultimately leads to the sanctions. And the national emergencies can be for almost anything. And they don't all, some of them have been going on for decades with respect to being used as justifications for the sanctions. So you have a national emergency declared, and then you sanction Nicaragua because of corruption in Nicaragua. Or I mean, this is the kind of thing that's happening at the level of domestic law in the United States. And we can't ignore that, because the United States is sort of at the forefront of many of the sanctions practices that exist in the world. It's been one of the early adopters and most prolific adopters of sanctions. And it has the geopolitical clout to influence other countries to join its sanctions or to collaborate and have similar sanctions. So what the United States does in this regard is rather important, and the kinds of emergencies that are used at the domestic level to justify U.S. sanctions are not necessarily the kinds of emergencies that are foreseen by the ICCPR as justification for derogating from one's human rights obligations as a state. So there's this whole question about what an emergency is, but it has to be addressed at two different levels, I think, for the idea of a global emergency to work. There's also much to be defined, as Irina said, about the nature of global emergency. Is climate change a global emergency? There are people in some small island developing states that would say, yeah, it sure is. But what about in Switzerland or the Netherlands or France, or, well, it's a little emergency maybe around the fringes of some countries. There's going to be a lot of disagreement on almost every aspect of this, but the concept is very interesting because it can create a legal space for sanctions that may otherwise, unilateral sanctions that may otherwise be considered illegal under international law to exist.
Mm-hmm. Yeah, thank you. Alena, would you like to add something?
No, yeah, actually a lot of issues, and I think that we will discuss further about human rights dimension of sanctions per se, and actually application of sanctions because of the corporate actors' involvement in the human rights violations. And in this regard, I think that when we're talking about human rights sanctions, it's another perspective to look at actually sanctions regime. And from one side, if we talk about application of sanctions because state duty to protect and consider sanctions as something like a last resort. From one side, it opens the door for application sanctions by individual states or collectively. From another side, it restricts states that they should actually provide explanation, provide reasoning why they think that they don't have another instruments to impact on the behavior of corporate actors, that they actually should go to this last resort and apply sanctions. Because what I see, probably I'm wrong, but what I see states, they my feeling is that they apply sanctions not as a last resort, you know. No, so there is a question for me, because I think that, yeah, actually it should be do this way. And to be back to the argument about the state duty to protect, first of all, of course, if it correlates with question about the extraterritoriality. If state actually considers that behavior of specific corporate actors, or in specific situation, behavior of corporate actors impacts human rights of its citizens in negative way, or create a huge risk of such negative impact, I believe that state duty to protect covers application of sanctions, because this state could have any other mean to impact on the behavior of these corporate actors. But another question, if other states could apply sanctions because some corporate actors impact negatively on human rights of citizens of another state. And I believe that it could be legal, it could be considered as comply with the rule of law, because of the principle of solidarity, which is also a part of international law. Actually, so it could be it could be an issue of discussion, but I think that the concept could be built around of these principles. As about emergency, no, to be honest, I think that we could have some parallels with derogation of international human rights obligations, because we have the mechanism of derogation, but we know that the derogation should not lead that we will lose the content of human rights. So in any case, we should not lose the content of the rule of law. No, you know, it should be still effective. But at the same time, the international human rights law is saying that the state could derogate, but the state, no, of course, we have human rights which could not be derogated, but the state should explain that this derogation was proportional, that this derogation was needed, and this derogation was also the last resort. No, you know, so I don't think that we need to know very specifically what is global emergency or what is national emergency. It could be the margin of appreciation of the states, but the states are restricted by the need to provide this reasoning of considering this situation as emergency, I would say.
Mm-hmm. And you know what? I would like to ask, actually, and you firstly, because you just put this thesis and the other our speakers. But don't you think that human rights derogation is already derogation from the rule of law principle, is already exception? And don't we, so it means that if we are saying that we can somehow find the legal ground for other derogation regime, it's like, for me, it sounds like we have to invent exceptions from exceptions. Don't you think so?
Yeah, in fact, you're right. And it too is a very interesting dilemma, because on one hand, you have the traditional arguments for unilateral sanctions not being in compliance with international law, that is not being authorized by the Security Council, or they're not legal, a legal form of countermeasure against another country's violation of international law, or they're not part of a prearranged mechanism in which you agree in advance to be subject to sanctions as part of, for example, a dispute settlement mechanism. But I would think, and I have argued, in fact, that it has been shown first by the Security Council authorized sanctions, and subsequently by all of these various unilateral sanctions and regional sanctions, that human rights do get violated, generally inadvertently, but it happens. And a corrective measure has been these humanitarian exemptions and exclusions from sanctions, but they too tend to not work because of overcompliance and other things. But when you violate human rights as in the course of applying sanctions, when you violate human rights in a country that's targeted either by the country being targeted or by corporations in the country being targeted or something like that, when this results in human rights violations, very difficult to correct, and at the same time maintain a degree of effectiveness of the sanctions that make them worthwhile. The knowledge, I think, that human rights do get violated with sanctions is, I think, at this point, studied well enough that it should be apparent to companies or countries that impose sanctions that this is going to happen. And they do take this into account in their humanitarian exemptions or in other ways to try to alleviate, offset the impact of it. The problem is that they don't completely offset the impact of it. And so you still have this residual problem involving human rights when sanctions are imposed. And does that mean that when sanctions are imposed by a country, does that mean that that is a intentional act, knowing in advance that some human rights will be violated in the targeted state? And what does that do to the legality of the sanctions? And, you get this question of proportionality that comes in to all of this as well. And just to mention something about what Elena was saying about sanctions not really necessarily being the last resort, we're seeing what I think is a fairly dangerous trend in which sanctions are often or more often being used as a first resort. One of the problems with sanctions in general is that they have a relatively good connotation because they don't involve armed conflict. Even though some of the results would be violating the Geneva Conventions if they occurred during armed conflict in a human rights perspective. But that said, what I find dangerous is how often you come across cases where sanctions are being used as a first resort. And the most obvious recent example, I guess, is with the sanctions imposed by ECOWAS against various states, members and not, within Africa, within the region of West Africa, right after a coup d'etat. When there was a coup d'etat in Mali in 2000, ECOWAS decided on sanctions against Mali within a day or two. And the same thing has now happened with Niger. And there was just an article let me find it here. There was just an article from the Associated Press a couple of days ago saying how much the people in the country are suffering as a result of sanctions imposed by ECOWAS against Niger because of the coup d'etat that just happened there. And these are being done before any thought or analysis can be possibly made about the impact of sanctions. So all of these play into questions of, are the sanctions legal? If they violate human rights and they're known in advance to violate at least some human rights, and the role of the proportionality question.
Okay, and actually, I think that we can move logically to the next question. Already we were talking about, Michael just finished his interaction with the word proportionality. And in context of business and human rights, can we say that application of sanctions have to be based, application of sanctions be based on an assessment of the involvement of the business enterprise in an adverse impact of human rights. So direct or indirect contribution. And just before this meeting, Alena shared with me the last news about just, for example, the National Agency on Corruption Prevention of Ukraine included the Nestle in the list of international sponsors of the war because Nestle products continues to operate in the aggressor state, supplying goods to its population and expanding its production base in the country. So, and it leads us logically to the question, should or could just mere fact of payment of taxes to the budget of the Russia, for example, be considered as a reason of sanctions application? And should we measure this, should the answer, sanctions answer, be proportional to the adverse impact on human rights?
Well, I can mention something. One of the things that I have noticed is that as a result of the UN guiding principles on business and human rights, and the impetus of some countries, some states, to embody at least some of these obligations into their own domestic laws, you do have more and more companies around the world that are developing human rights policies. And that's a good thing. What's not so good,
not bad.
yeah, what's not so good is that these policies tend to be somewhat, the parameters tend to be somewhat restricted. They will normally focus on, we won't engage with slave labor, we won't do business with suppliers who engage with slave labor or child labor, or things like that. But I have not seen any policy of any company that I mean, there are thousands and thousands of companies, so I obviously haven't looked at the vast majority, but you look at a few influential ones to get an idea of what these are about, and I haven't seen any that take into account the human rights impact, any of these human rights policies of companies that take into account the human rights impact of their sanctions policies and the risk assessment that goes into them that may lead to overcompliance with the sanctions. And that,
you mean, excuse me, can I clarify? You mean that these policies does not contain the information about impact of sanctions applied against these companies? I mean, if or what, could you clarify just what exactly?
the way a company complies with sanctions can have a human rights impact.
Okay.
And this generally is never touched in the human rights policies of the companies. And I think in part because it's not even on their radar screen to think about this aspect of human rights. But when a company is an international company or does business internationally, its actions can affect human rights in other countries. And because human rights are a global obligation, and a company's business may be global, I would think that, it's an emerging area that they need to consider. Partly, I think they haven't considered it because the whole issue of sanctions and the human rights consequences of sanctions is so new. There's really very little for many companies and even governments to go on as guidance on how do you even determine this? But at least it should be somehow be considered, I would think, in human rights policies of companies under the guiding principles or under national regulations that are aligned with the guiding principles, because there are consequences. At the same time, there are consequences of not sanctioning. So the whole thing is very kind of in a state of flux right now in terms of the knowledge and in terms of acting on the knowledge on the part of companies.
And you know what? I think that a very important moment, which usually, actually, when we are talking about sanctions impact on and unilateral coercive measures on human rights, we sometimes lose and I think that in the work of UN Special Rapporteur on unilateral coercive measures, this factor is lost completely. I think that we have to look at this in the frame of balance, in the frame of link of sanctions and reasons why these sanctions have been imposed. Because sanctions, as just Irina very right said from the very beginning, that there is no unilateral approach, but to the nature of sanctions and legal nature as well, they're very different. But to my mind, for example, sanctions is the main role of sanctions, at least how actors who imposed sanctions put in their legal documents, whatever it can be, but and UN sanctions and domestic sanctions in accordance with domestic jurisdiction, domestic law. The main role of sanctions is to influence and to change behavior of subject, of actor, in relation to which the sanctions are imposed. And in these connections, sometimes the very fast way to stop sanctions just to change your behavior. I mean, to change your illegal behavior for actor who's acting illegally. And got sanctions for this. So, of course, I mean, it's not just, I mean, all cases is very different. And the basis, and is to the question, again, of the first resort or last resort, but in principle, I think that we have to bear in mind this factor. Then, we're coming to the question that I'm interested to discuss very much. This question is, generally, can we say that sanctions can be considered as an effective tool in the business and human rights context? What I mean, two moments. I would like you to comment on and to share your views. First of all, when we evaluate companies as a good or bad, just based on our evaluation on the fact of living or staying of the companies in, for example, authoritarian regimes in the states who involved in the gross violation of human rights in Russia, in Belarus, just close examples. We have to bear in mind that like living, when company is leaving the state because of sanctions, and when company is leaving the state because of its own policies, because of its own decision to leave the state, because of such a human rights violation, because it's in contradiction with its company's values. Is a different things, because when company is leaving because of sanctions, we can't say actually that all companies that are leaving states because of sanctions, states in which gross violations are happening, or states which violate human rights in another jurisdiction, that all these companies share these human rights values, because when they live in a state because of sanctions, they just have to comply with the regulator decision. And in this connection, sometimes not all companies who leave the country, who interrupt all business relations with this country because of sanctions, indeed really human rights funds, And the second moment, and this also about authoritarian regimes and businesses operating in these regimes in authoritarian context. Another example, when sometimes it can happen so that really good businesses, I mean businesses who have these human rights policies not as declarative, but who is really share these values and try to do their best in human rights due diligence, and when they are acting and try to do their best to bring these standards, at least in their work, in their internal processes of working in relation to its workers, at least operating in this authoritarian country, sometimes it can be the last hope for the people working in such companies. Because the situation in their state in general, absolutely, so their state just doesn't care about them. And this company can be the only actor who somehow cares about them. It was very good examples of this in Belarus in 2020 when we have our protests. And it was also a lot of questions about these international businesses who has a partnership ties and who was working in our country. So in the light of all this that I'm just said, how do you think, can we actually can we look at the sanctions as the effective tool in the business and human rights context?
I can say something about that. In fact, just all of these pros and cons from a human rights perspective can be very intertwined. And the example, for example, of Nestle doing business in Russia. Well, let's say Nestle makes a lot of money in Russia, which is why it stays there.
Mhm.
Okay. It is perhaps staying there in order to comply with domestic securities law that says you take your corporate decisions in the best interests of your shareholders, and making money is in the best interest of the shareholders. If you have sanctions against Nestle for doing this, the sanctions might give a company like that sort of a legal cover for not doing business with Russia. And then it becomes a question of which law takes precedence. And that's where the stuff we were talking about a little earlier about having some sort of global, well, whether it's global emergency or something else that establishes the legality of unilateral sanctions at the international level might come into play. But yeah, sanctions. Let's say Nestle makes money in Russia, so they stay in business there because they don't want to violate domestic security laws of Switzerland. Let's say, I don't know what the domestic laws are, but they're all fairly similar in a lot of countries. Okay, then you have Ukraine saying we're imposing sanctions against Nestle because they're doing business in Russia. Well, that may give Nestle a legal cover in Switzerland for arguing, well, we're going to pull out of Russia, and this is the reason, even if we're not going to benefit our shareholders. Okay, but then what happens to the employees of Nestle in Russia? As you were just mentioning, Ekaterina, the right to work. What if that gets affected? And the right to food, which is one of the rights that Nestle promotes and participates in by its very business. So you have all of these cross currents existing in these kinds of questions, and some of them are very directly related to human rights. Others are related to other aspects of law. But here is where I think webinars like this are really good for bringing these issues out, because they need to be studied. Eventually, perhaps there will be kind of a hierarchy of which laws take precedence, and how human rights play into this process.
Mm-hmm. Alina, you would like to comment?
Yeah, just a very, very brief comment.
Mhm.
Actually, to respond to the previous Michael's comments about
Mhm.
that companies don't apply human rights due diligence or human rights impact if they, for example, exit because of sanctions or something like that. Actually, it's interesting situation that actually companies, some companies stay in Russia or in Belarus or in other countries because they refer to the human rights impact if they exit from these markets. And it's very interesting point because it needs to be actually very reasonable, and it needs to be explained what actually human rights will be impacted if this company, for example, will exit, and what involvement of this company in human rights violations by the state if this company stay. So actually these questions are very Katerina's question about taxation, for example, and remark from Michael about human rights impact of existing from company from the market. They are very linked to each other because when companies stay, it should assess what impact such staying will have on human rights, not just in this country, but also, and first of all, in human rights violations which are caused by the state. And is this company involved in these violations or not? And actually, for me, it's a key point that when we're talking about human rights impact, we need to indicate what human rights and will these human rights be impacted if this company will stop to provide some services and goods? Because to my mind, actually, it's very, very complicated to find a good example in Russia, because human rights actually will not be violated by exiting of some companies, human rights on food. So it's another discussion. As about taxation, I think that, and actually there is a position of John Ruggie, and there is a position of this year paper of High Commissioner for Human Rights that paying taxation per se is not involvement in human rights violation. But I think that we need to apply a business and human rights framework to this question and to consider this question through the lenses of leverage of this company. So if the paying taxation could be considered as a leverage of this company to the political regime, to the general situation, we should say that this is involvement of this company in human rights violation. If it's minor paying of taxation, it's not.
Yeah, it's very, very good point. Irina, please.
Yeah, I would like to quickly go back to this argument about Nestlé. And in this context, I think what is important to mention in this context, in particular, if, for example, Ukraine sanctions some companies for working with Russia or sanctions Russian companies. Here's the question whether it's permitted or not permitted. It might depend on a country that has imposed such type of restriction, in particular the circumstances, because it is well known and well established practice to prohibit trade with the enemy in times of military conflicts. So, for example, historically looking, during the First and Second World Wars, countries prohibited trade and economic relations with the enemies, and in some cases even blacklisted foreign entities and individuals engaged in business transactions with their enemies. So it's not only you sanction your enemy, but also entities which might provide certain goods, services to your enemy. And abundance of such state practice demonstrates that there is a general acceptance that such practice might be allowed during the times of war, which is important clarification here. And another issue which is also important is that, for example, in Eritrea, Ethiopian Claims Commission, there was a discussion of if a country might freeze assets of a foreign country when it engaged in a military confrontation with this foreign country. And it was said that there is a right to freeze or otherwise control or restrict the resources of enemy nationals so as to deny them to the enemy state. So again, I think it will be important for our discussion to clarify that when we look at the Ukrainian practice, especially with respect to Russian companies, or companies owned by Russian nationals or state, or when we are talking about countries that significantly contribute to Russia, we should still put it that we are talking about in the context of international military conflict in which these countries engage. So it kind of might shift a bit angle of discussion, because if there will be no military confrontation, then obviously this practice will be a very extreme kind of type of measure. But then again, there are a bit different perspective when we add military conflict to this. And a very brief comment on effectiveness, because I don't want to take too much time. In fact, if you look at the literature on economic sanctions, the question of effectiveness is one of the core questions which is discussed in literature. It's not only discussed by lawyers, but significant contributions made by political scientists and economists who look at different frameworks, who try to see how sanctions should be framed in order to bring change. And then again, with respect to human rights, there have been a bit of literature on whether sanctions make human rights situation worse in countries which are sanctioned, or do they improve? And there is different outcomes. And I think I will conclude with this. If there will be questions, we might discuss it.
Although in fact, it's great that you mentioned this, because it also brings up the issue of the WTO national security exceptions, which allow countries to derogate from their WTO obligations when there is a situation like an armed conflict.
Yes, thank you, colleagues. So, well, firstly, we have almost finished, but we have Iurii just joined us. Unfortunately, just in the end of discussion, but still, I can't not to ask no question. So actually, we discussed a lot before you joined us, but still, can you maybe say a couple of words about your personal vision, which challenges to rule of law you see in relation to sanctions application to corporate actors?
Thank you very much, Ekaterina, and please accept my apologize, because I was busy in another meeting, which I could not take a part. And if you allow me, I will go on Ukraine to deliver on all information what I want to share with you. І декілька слів. Дійсно, санкційна політика України є унікальною, тому що насправді слід оцінювати всі дії органів нашої влади крізь призму того, що після Другої світової війни ми перша демократична країна, на території якої ведуться повномасштабні бойові дії. І це дійсно момент, він можливо емоційний, але для юриста так само вкрай важливий. Щодо санкційної політики, я трішки preliminary remarks, потім перейду до того питання, які виклики для верховенства права. Насправді цікава історія, тому що у нас задіяний специфічний механізм у вигляді Ради національної безпеки і оборони, структура, яка задумувалась розробниками Конституції як дорадчий орган при президентові, починаючи з часів Віктора Ющенка, поступово набирала свої ваги і вже оформилась вже за часів Порошенка і Зеленського оформився як повноцінний центр влади. Тобто це такий альтернативний уряд, який займається вже не тільки оборонними питаннями, координацією зусиль в цій сфері, але й, звичайно, приймає повноцінні рішення. І у нас є 3 типи санкцій згідно чинного закону. Це ті, які запроваджуються РНБО і потім вводяться в дію указами президента. Ті санкції, які запроваджуються РНБО, санкціонуються президентами, потім вже оформлюються рішенням Верховної Ради, тобто це секторальні санкції. Ну і третій унікальний український вид санкцій, той, який приймається за рішенням суду. Теж, знову-таки, фактично за подання РНБО, але ініціатором є Мін'юст, я про це хотів би окремо сказати. Дивіться, десь більше року тому виникла ідея в парламенті запровадити нові санкції у вигляді конфіскації всіх активів. Я намагався дізнатись, в чому ж полягали мотиви такої ініціативи. Насамперед депутати вказували на те, що у нас недостатньо механізмів для того, щоб впливати на державу-агресора. Ми всі розуміємо, і я про це ще скажу, і ви про це так само слушно казали, що санкції не є видом відповідальності, це скоріше засіб притягнення засіб, точніше, впливу на суб'єкти і так далі. Однак наш законодавець вирішив, що цього замало, і пішли через запровадження цієї санкції. А чому задіяли суд? Бо чинна Конституція в статті 41 дозволяє конфіскацію виключно за рішенням суду. І, як це не дивно, ініціатива, яка виникла всередині президентської фракції, наткнулась на вето президента. Вже прийнятий закон був заветований. Що вимагав президент при перегляді цього закону? Ну, звичайно, там суто інституційний дизайн, не буду в це занурюватись, але він говорив про те, що ми вже маємо на той момент і зараз ми маємо спеціальний закон, який говорить про конфіскацію всіх активів Російської Федерації. Він називається «Про основні засади примусового вилучення в Україні об'єктів прав власності Російської Федерації та її резидентів». Цей закон є спеціальним щодо активів громадян та юридичних осіб Російської Федерації, держави як суб'єкта приватного права. Він там трохи відтермінований, але наразі. І, звичайно, президент наполягав на тому, що те, що ви говорите, rule of law, вимоги ці верховенства права, давайте врахуйте, бо судові процедури були не деталізовані і підстави виписані через такі занадто оціночні категорії. Ну, в результаті деталізували, але не настільки, щоб можна було сказати чітко, що це є конкретні критерії. Зокрема, зверну вашу увагу, те, що ви казали про сплату податків, от чітка підстава для застосування цієї санкції. Знову ж таки, хочу сказати, що є певний дисонанс, бо в нашій теорії права санкція стосується миру, перепрошую, як міра примусу до правопорушника і вкладається в межах інституту відповідальності, да? А якщо говорити про конфіскацію. А тут якраз конфіскація – це з одного боку не відповідальність, але по факту є санкцією. Так от, якщо юридична особа сплачує 40 мільйонів гривень, це трохи більше $1 мільйона, а якщо це про фізичну особу 3 мільйона гривень, це десь 75-80 тисяч доларів, то цього достатньо, щоб до цієї особи застосували цю санкцію. Хто її застосовує? Її застосовує, у нас є спеціалізована інституція, Вищий антикорупційний суд. Чому це віддали Вищому антикорупційному суду, я не знаю. І я спілкувався от вчора буквально з суддями апеляційної палати Вищого антикорупційного суду. Ну, вони так сприймали, сказали, нам сказали, ми працюємо. Да? От. І практика дуже проста. Ну, перше, те, на що наголошують юристи. Суд повинен мати відповідний дискреційний інструментарій розгляду і вирішення спору. Тобто він, коли отримує позов, має проаналізувати всі юридичні обставини значимі і якісь рішення ухвалити, в тому числі і визначити, наприклад, спосіб захисту того чи іншого права. В цій ситуації законодавець обмежив дуже просто. Суд повинен або застосувати санкцію, або відмовити санкцію. Що відразу вилазить на поверхню, те, про що говорять всі юристи, це права третіх осіб. Тобто, коли ми маємо справу з корпоративною власністю, то конфіскується всі 100%, незалежно від того, що міноритарні акціонери не задіяні до цих процесів. Знову ж таки, що цікаво, суд, мабуть, що в рішеннях сам себе переконуючи по 10 разів, це так ми з Оленою Олександрівною аналізували цю практику, якось по-шкілярському кожного разу, чи виправдовуючись, чи говорячи, що ця санкція є винятковим заходом, мовно, гостротою становища і так далі. Я, до речі, у суддів запитав, кажу, а що, закрите ж засідання, я кажу, не деталізуйте, поясніть, що вам там показують. Вони кажуть, особливо нічого не показують. Каже, раніше просто був позов, зараз Міністерство юстиції щось СБУ дає, якісь там закриті дані і так далі. Те, що ми бачимо з аналізу відкритих джерел, от простий приклад, ректор сусіднього з нами Білгородського університету попав спочатку під санкції за те, що підтримав агресію цього Путлера, диктатора, і після цього він продовжував цю діяльність, там виступав перед студентами і так далі. Суд сказав, Мін'юст звернувся до суду, каже, ви бачите, він не зупиняється. Давайте щось з ним робити. Ну, що робити? Забрали у нього квартиру, там ще щось у нього майно було і так далі. До речі, суд активно використовує доктрину переваги більш вагомих доказів, оскільки по факту так виходить, що змагальності процесу як такового не відбувається. Ще зважте на те, що законодавець дуже така процесуальна економія, дуже обмежив строк. Да? Там 2 дні на подачу відзиву на позов, там 10 днів на подачу апеляції і так далі. При цьому, що апеляційне скарження на цьому крапка, апеляційне скарження відбувається в самому ж цьому Вищому антикорупційному суду. Суд там говорить про інформаційне сприяння агресії, суд говорить про використання можливе майна і так далі. І знову ж таки, от постійно суд наголошує на цій доктрині. Вона, знаєте, чому дисонує? Бо ця доктрина винесення рішення на користь тієї сторони, сукупність доказів, які є більш переконливі, да? Вона є адекватною для адміністративного судочинства, коли громадянин позивається до влади. І якби там діє презумпція винуватості влади, тому що якби для цього і створена адміністративна юстиція, що хай влада доведе, що вона права, а не позивати, що він має достатньо аргументів. Тут якось вийшло навпаки, да, що влада каже, завчасно діє, якось перевернули цей кодекс адміністративного судочинства, бо незважаючи на те, що суд антикорупційний, справа розглядається в межах адміністративного судочинства. І тут цю доктрину перевернули, і тепер влада каже, він не правий, хай доводить, що він не правий. Тобто, получилась історія такого звичайного цивільного спору, де є рівність і так далі. Я, звичайно, можу, щоб не перебирати час, ну, до речі, знову ж таки, те, що я сказав, якось суд постійно, якось йому неудобно, він каже, ну, ми змушені це робити, що от навіть в рішеннях постійно повторюючи, що санкція не є результатом встановлення ознак кримінального правопорушення, як в розумінні національного законодавства, так і міжнародного права. Я хочу цей такий поверховий аналіз завершити декількома речами. Звичайно, ми, як юристи, маємо бути формальними, безсторонними, ну, на то у Феміди зав'язані очі, хоча у неї вуха чують, що відбувається. Відбувається війна, відбуваються емоції. Я, спілкуючись з колегами, чітко розумію той внутрішній контент, який не завжди виноситься наружу. Вони кажуть, ми чітко розуміємо, що коли, ну, вибачте, я назву речі, багато цих уродів підуть до Європейського суду з прав людини, хай мене дівчата перепрошують. Так, вони просто отримують сатисфакцію через порушення статті 1 протоколу, там вільне володіння власністю і так далі. Мене, як фахівця, я дякую Олені Олександрівні, вона мене потроху вчить бізнесу і правам людини. Я людина далека від цієї тематики, займаюся скромно конституційним правом і теорією войовничої демократії. Мене цікавить, як формуються тоталітарні нації. Я дивлюся, як там у орків все це відбувається. То я з подивом, у них там був знову черговий той юридичний форум, і що мене здивувало? Ми кажемо, давайте застосовувати стандарти міжнародного права. Ми цивілізована країна, все. З нами воює країна, яка не визнає стандартів міжнародного права, але вимагає від нас їх застосовувати. І я приведу це на конкретному прикладі. Відбувається у них юридичний форум, посадовець Мін'юсту. Йому кажуть, там наші співвітчизники страждають в країнах Балтії і так далі. Кажуть, які проблеми? Кажуть, країни ж Балтії виконують Конвенцію про захист прав людини. Позивайтесь в Євросуд. Каже, да, ми відмовились, але вони ж ще є учасниками. Да, тому давайте ви йдіть, бо вони ж дурні, вони там залишились. Вони мають виконувати ці міжнародні стандарти, а ми ні. У нас суверенна демократія і Конституція має верховенство над усім. Тому я, відповідаючи, пані Катерино, дуже коротко на ваше питання, хочу сказати, що дійсно порушення верховенства права є, але поки йде війна, я думаю, про них можна і помовчати. Дякую.
Дякую. Thank you very much, Iurii, for such insights. I can just say, that personally, me, as a citizen of state aggressor, I have frozen my finance my bank account in Ukrainian bank, and bearing fully the burden of being citizen of state aggressor, I hope still to get my money back sometime, someday. So, and don't lose this hope. I don't know, under this regulation or under some else regulation, but just such situation I have. So actually, colleagues, we are already over out of time. Maybe just we have a couple of questions, but Elena already discussed some questions in the chat, and we have I should read just for person to be heard the one point of view that Ukrainian blacklisting is about naming and shaming, but not sanctioning, with a bit of unclear criteria. Who would think companies think it would hurt? And this is also a thesis and point. So maybe just final remarks, colleagues, if you would like to make some final remarks on this discussion, and we can already finish, because the people I see that just leaving already. Bogdan, please.
Yeah, just a small comment on what Iurii was saying. Yeah, first of all, with regard to all that cases of High Anti-Corruption Court of Ukraine, Institute of Legislative Ideas is trying to support this case law and to make it compliant with the European Court of Human Rights case law. So we are doing everything so that to follow the rule of law principles in the case law of the High Anti-Corruption Court of Ukraine. And by the way, all the cases, we closely monitor all the cases and all the issues that Iurii mentioned with regard to terms, to the standard of proof, and to all the other issues. We address those issues in our analytical paper, and we try to help judges to adhere to the European Convention on Human Rights with our analytical support. That's the first thing I wanted to say. And on the chat, I also posted a link that might be useful to anyone who wants to more closely address those cases. We monitor all of them. There are 30 so far. And yeah, and the second point I was also wanted to add to what Iurii was saying is that, yeah, rule of law, I am a huge fan of a rule of law, but the rule of law should not become something that will make us helpless in the face of existential threat. So if we are too cautious, we will become absolutely helpless, and that's not the effect the rule of law should produce. Thank you.
Thank you, Bogdan. Yes, it's understandable. And so, colleagues, I think if nobody else has some remarks, I think I can say thank you very much for inviting me to moderate the discussion. Thank you, Elena, very much. Thank you, Michael and Irina and Iurii, very much for your inputs and your thoughts. I think it's a very important topic that we discussed, and I think that it will help. It cannot like resolve everything, but it can help maybe to someone to have something more, more structured in his head. I don't know. Yeah, and in principle, maybe it's very good, to discuss in the light of all these events. Just good that we are just discussing, but not doing something, some bad things.
If I can just
speaking,
make one quick comment based on what Martin just said. Elena's comments on the duty to protect are very, very interesting, and it may indeed be one of the ways to break out of whatever negative constraints might be in existence as a result of strict rule of law. So.
Yes, thank you. So, colleagues, Irina.
Just one very small comment to the question in the chat to Kirill, it goes. So, in fact, there is such type of kind of hidden sanctions, which is called consumer boycotts. So in some countries, for example, in China, they're very effective. So even naming and shaming, if it taken in some sort of very political sense, on very political sensitive issues, just even describing some company or some business that supports certain ideas which are against a country, nation, or its interests, might result in people just denying or deciding not to buy certain types of goods. So at least historically, if we look at the practice of China, for example, there have been few times when businesses went almost bankrupt just because they were named and shamed as businesses that supported ideas which were considered to be contrary to national security vision of China. So this is thanks.
Thank you. So then I think that we can finish our meeting. Thank you to everybody and all the best.
Yeah, thank you very much, and thank you for moderation.
Thank you.
It was nice to see you all. Bye.
Yeah, bye.
Bye-bye.